Good evening. This is Steve Weil with RMS Accounting and Royal Management Services, and I want to welcome you to our Condo Board Certification class. The course is presented by Royal Management Services, and we manage condominiums, co-ops, and HOAs for boards of directors. Welcome. We're glad to have you with us. And let's get started. We're going to start out by telling you what we're going to cover today. This class is going to cover a little bit about the law that you have to deal with. We're going to talk about fiduciary responsibility. That's what you have to deal with as a board member. When you join the board, you become a fiduciary and you have a fiduciary responsibility to your association. We'll talk a little bit about that. We're going to talk about the governing documents, those things that for many of your associations were written long ago and that some have been updated, some have not. But we're going to talk about what they are and how they work. We're going to talk about the board of directors and the officers and kind of go over that with you. We'll also talk about association official records. And then we're going to talk about financial reporting. We're going to talk about what is required by the state of Florida. That's not nearly enough. There's more that you should get as a board because you need to know what's going on in your association, and you're responsible for what's financially going on in your association. So we're going to talk about budgets for both maintenance and for reserves. Most of the people I see, I ask them why they showed up when we do this live, and they say they want to know how to get people to do things. They want to know about enforcement. How do you get people to comply with the rules? We'll talk a little bit about that. And we'll also talk just a little bit about the election process. So we've got a lot to cover, and we're going to try and make it relevant to you and what's going on in your associations. Let's start out with the law. If you are in a condo, you are governed by 718 of the Florida Code. 718 governs how condominiums act, what condominiums can do, and it really is the basis of the condo law in Florida. Now, if you're a co-op, that means you're governed by 719, which is the Cooperative Act. Close to a lot of what the condo has, but not quite as sophisticated. And if you're in 720, you are in a homeowners association, you fall under 720. And interestingly enough, what code section you fall under is not determined by, oh, I'm in a high-rise condominium building, or I'm in a single-family home in an association. It's determined by your governing docs and what they set you up to be and what they say. So I've told you what section of law governs your kind of community, and we're going to talk about how you can find that and how you can look at it in a minute. But oftentimes people think that that's the only thing that matters. There's one section of law, it governs condominiums or HOAs, and that's all as a board we have to know about or deal with. And that's just not true. Because in addition to that, most of your associations are set up as nonprofit corporations. And nonprofits are governed under 617 of the Florida Code. So if you're going to have to understand that, and that sets the rules for what the minimum number of directors are, what happens if a nonprofit organization doesn't have enough people for the board of directors, how are meetings called and controlled. So you're also going to need to deal with that because it governs how your association is governed. And it doesn't matter whether you're an HOA, a cooperative, or a condominium association. Now, we got rid of some of the Florida law, but we then have things like the federal fair housing law. That prohibits discrimination based on race, religion, skin color, or national origin, and family status. It prohibits discrimination based on disability. It prohibits discrimination, based on age. So it's important that we know that because violating the Federal Fair Housing Act can end up costing you huge fines, and your association can be sued by somebody that is treated wrongly under the Federal Fair Housing Act, putting all of the owners at risk. Add to that, we have all sorts of state, county, and local laws, things like building code, fire code, all of which have to be complied with, and all of which come through separate actions of separate governments and can be applied to your association. A lot of law to deal with. and hopefully most of us aren't lawyers, and we're just lay people, and we need to know, how do we deal with it? Well, the good news is that all of the Florida law is online. So you can nowadays, don't have to have a bunch of expensive law books. You can go online and look it up at the state of Florida's site. And they, my slide is old, but they actually do update it every year. Okay. And you can pull up the different parts of the Florida condominium or co-op code, or you even have the option here to run the full text, which is just hundreds of pages. But if you're like me and don't remember where something is by section or subsection, you pull the whole set into your computer, you expand it out, and then you do a search for whatever you're looking for. If I'm looking for elections, I do a word search for election. It'll skip from one election citation to another. I can find everything I need. If I'm looking for something on meetings, I can go through all of the different meeting requirements by doing a search for those. So all this is great. It's online, not encouraging you to be a lawyer and try and interpret the law, but in many cases, it's fairly clear, and at least to give you an idea of what's required. This is a great place to go and look up when you're trying to figure out, can we, can't we, what's going on, before you get your lawyer involved. Now, if it's a question of what the law means or how to interpret it, certainly you should be speaking to your attorneys, but this gives you a basic knowledge of what to talk about and where you're going from there. We also have the same thing for 720, of course, and 617. Great places to go and look and see, gee, what do we have to do? What are the rules? What's required? It's easy. You can look it up at home and at least get an idea before you have that discussion with your legal counsel of what do you really need to know and what don't you understand. All right, so the first lesson here is when a real legal question comes up, it's not just a can I, can't I, what is something simple in the law, you're not sure about how to apply anything you're looking up, or you have a question about something going on in your association, before you take action, call your attorney. Big secret, attorneys are a lot cheaper before you need them to solve your problem and at helping you stay out of a problem than they are at solving the problem afterwards. So I do recommend that if there's something comes up, the board communicates it with their attorney. The secret here is often how you communicate with your attorney. You don't want 9 different people from the board calling them. You're going to get 9 different bills. If you can and you have a manager, then the manager can probably coordinate through the attorney for you. If you don't, the president of the association or somebody duly appointed by the board can do that. But don't ask open-ended questions, and tell your attorney when you ask the question what you expect. Hey, I don't want 200 pages of citations and cases that say maybe at the end. I want to know, if I do X, what's the worst thing that can happen to me? And what are the chances of that happening? I want some kind of a definitive answer. I tell attorneys all the time that they like to give lots of information, but often it's not actionable. And when I'm dealing with an attorney, I want actionable information. Tell me what happens if I go way A, or what happens if I go way B, what the risks are, and I'll be happy to make the decision as a manager or a board member and move forward. So don't leave your legal counsel out, but get that in writing, those opinions, so that you can use them again and again and you don't have to go back for the same thing. All right, so let's talk about fiduciary duty. When you are elected to the board of directors, you have a fiduciary duty. That is a special duty to put the association before your own needs, just like a trustee would have for the person whose trust he's managing. I can't put my own needs before that of the association. I have a fiduciary duty to them. It creates a special obligation or interest. Examples, as I said, trustees, guardians, corporate officers. You can't decide what's best for you and then, the association comes second. You have a special duty to your association. It's more than just an ordinary business relationship. It's a special relationship. But who's that duty to? You got on the board of your association. Who do you think that duty is to? Is that duty to the people that elected you to the board? Is that duty to the board itself? Do you have a duty to your fellow board members? Is it to the owners of the association? Or is it to the association itself? Okay, I put it to you that while many people think that their duty is to the owners, it's really to the association itself. Sometimes the interests of the association owners and the association line up. But we recently had an association where the owners felt that the fact that the balconies were getting ready to fall off the building and they were gonna have to get a special assessment for it was not important, because after all, it was a group of elderly people. They were on a fixed income and they did not want to do the necessary repairs according to the engineer because they did not feel it was warranted. We don't really go on the balcony. But the board of directors had a duty to the association to make it safe regardless of what the owners wanted. And they had to do the balcony restoration, even though a large percentage of the owners objected to it because they didn't want to have to pay for it. This was a safety issue in this case, and the needs of the association had to be put first before the needs of the individual owners. So if you want more information on fiduciary duty, I have a great article for you, and you can pull this up. I'm going to tell you, you don't need to try and do this link that's here, because everything that I'm going to show you and a lot of the backup materials, at the end of this presentation, you will be able to go to a private web page we have, and you'll be able to get all of these things, links, and download. And I will give you the address when we get to the end of the presentation. You can get copies of all the slides, a number of other pieces like this that we've put together and that we've taken from other sources. So you're going to get the information and have easy access to it, and you will eventually, this presentation will go there as well, so you'll have a way to go back and look up things and re-see parts of this presentation if you find it helpful. All right, so we're going to talk a little bit about the law. The law for Florida changed recently, about 2 years ago. An officer, director, or a manager may not solicit or accept anything of value or kickbacks. Now, you would think that this is like common sense and that they wouldn't need to like put it in the law, but people ignored it, and it is in the law now that you can't take a kickback as a manager, as a director. You can't solicit gifts. We've seen that happen where a president of an association or a manager of an association solicited the vendors for beneficial things, and that is not permitted. You can't do that, and it can't be provided to your family or somebody else. There are both civil and criminal penalties for doing this. So, not that your fiduciary interest is or your fiduciary responsibility is not enough, but Florida law also forbids you from soliciting gifts, favors, anything of value from the vendors of the association, as it does to the managers, as it does to all of the officers and directors. All right, so now we're to the governing docs. And I like this picture of governing docs because although a lot of ours are electronic now, it sometimes seems when you go look for something that they're huge, you can't carry them around. And I don't know about what you're dealing with, but I do know that a lot of the ones I see have been photocopied so many times that you can barely read them. We now have these wonderful governing docs, and the governing documents, if you're in a condo or co-op, include the articles of incorporation, the bylaws, that sets up how you have meetings and what the responsibilities are of the officers, the condominium documents, And then the policies is enacted by the present and past boards of directors, and rules as properly enacted by present and past boards of directors. All of these things make up the governing documents for a condominium association. If you're in an HOA, you're going to have articles of incorporation that set up the entity or the corporation that governs your association. You're going to have bylaws, but instead of having condo docs, you're going to have declarations of covenants and restrictions. And these become part of your deed, and they're like deed restrictions, and they attach to the property, restricting what you can do, giving you the requirements of what you're required to do, what the rights of the association are, and your rights as an owner. There would also be policies enacted by your present and previous boards, and any rules that were properly enacted. That would all be part of the governing docs. In all cases, you should have received a complete copy of the governing documents before you purchased into your community. The seller, not the management company, but the seller was responsible for providing you copies of the governing documents before you closed your purchase and purchased into your community. Okay, HOA covenants and restrictions, very important. Okay, condominiums go on forever, but HOAs, if the documents aren't preserved, and there's a specific thing that you have to do this, they expire 30 years from the date they were originally filed. Your community could go poof and not exist as a community, and trust me, because I've been there, done that, it is not any fun to have to redo one of these things and bring it back. You have to get everybody to sign off on it. You got to get documents to everybody. It is an expensive legal proposition if you allow it to expire. Preventing it from expiring is fairly easy, but it's one of the reasons your HOA needs to have an attorney on board, because that attorney, the first thing he should do when you hire him, before he does anything else, is determine what is the date you have to refile, revitalize, do your documents for them in order to stay active and not to expire after the 30 years. You can't make the clock doesn't run because you amended them, it doesn't stop because you changed. Your attorney needs to tell you, okay, we need to resubmit, we need to go through the process of restoring our documents before the 30-year clock, and here's when we need to start. And that is very, very important. I ran into a community that thought they were saving money. They refused to hire a lawyer. When we finally talked them into hiring a lawyer, they came on board with us, and we said, we need a lawyer to look at this stuff. And we found out that the community had not been legally allowed to collect their assessments for the last 5 years because their documents had expired and they were not revitalized. They literally had to reprint, get all the documents, get out to every owner, convince the owners to sign. All of the money that was owed to them for this previous period that the association had tried to collect could not be collected because it was not owed to them legally. Only going forward it could be. It was a huge mess. It took us almost a year to get it straightened out, and it was not cheap, okay? And this all could have been prevented if from board to board they would have known when they had to do this, and they would have had an attorney that could have kept them on the straight and narrow and made sure this happened, or even a management company that had mentioned you have to do this. And they hadn't. They just went from one to the next and did not hire legal counsel, and nobody knew that they had to revitalize their docs. Really important. Anyway, very important if you're in an HOA, and a lot of you are, that you really take this to heart. All of the authority for the board of directors that give you the authority to act, make rules, make decisions, pay bills, collect money, all of that authority comes from these governing documents. No governing documents, no authority. The fact that you're elected to the board or you're an officer does not give you authority. The governing documents give authority to the board of directors, and they limit the authority of the board of directors as well. So all your authority actually comes from the governing documents, not the other way around. Boards of directors cannot make changes to the governing documents. Only the owners can do that. How many owners need to vote to make a change depends on what's called for in the governing documents. We just sat down with a new association, and their governing documents say that any amendments must be approved by 100% of the owners. Now, that's unusual. There's a lot of them out there that are 80% or that have been amended to 50% plus one, but you can't just determine, well, there's a number. That number and that authority comes, and how you do it comes from the governing documents along with state law. All right, so we've got your board authority from the governing documents. Okay, the articles of incorporation set up the corporation. They set up the initial board of directors. Now, you're probably many boards down the road since then. And they set the initial registered agent. I want to just take a minute to talk about the registered agent. The registered agent is the person that gets notified if your association is going to be sued. So if I wanted to sue you, I would hire me a process server, and I'd send them out, and they would knock on your door at 5 a.m. in the morning or whenever they could find you. And when you came to the door, they would put the paper, they would hand you the papers, and they would tell you you've been served, and you can't go to court and say, I didn't know anything about this. It's really hard to hand a corporation that doesn't have a physical body, there's no human there, a set of papers. So Florida law says that all corporations must designate a registered agent. They say that the registered agent must be available between 9 and 5, Monday through Friday, and ready, willing, and available for service. The registered agent can be at a business address. The registered agent can be a person, or it can be a corporation that acts as registered agent. We, as our accounting firm, acts as registered agent for about 250 companies. Some of those are HOAs and co-ops and condo associations. Others of those are just Florida companies that need a registered agent and don't have somebody that's going to meet those requirements being in a designated business office, so they pay us to be their registered agent. But having your registered agent be a board member that spends half his time in New York or away, or who's not going to be home when the process server comes, is not a good idea. Attorneys can serve as registered agents. Management companies serve as registered agents. We serve as a corporate registered agent. Our only job as a registered agent when we receive a notice of service is to copy and make sure you receive that. Typically, we're going to email it or mail it certified mail to the designated party that we're supposed to contact. But we don't fight the lawsuit for you. We don't even comment on the lawsuit that's been filed. All we do is make sure that you are aware of the notice of service. And that's what the job of the registered agent is, to receive it and notify you. Okay, the bylaws. Bylaws spell out the responsibilities and the authority of the officers. So I have seen bylaws that give the president authority to make lots of decisions in the absence of a board meeting. I have also seen bylaws that severely limit the authority of the president or others to make decisions in the absence of a board meeting. All depends on what your bylaws say. How does a meeting get called? What authority does the president have? What authority does the treasurer have? What parties on the board or officers can sign checks? That's what the bylaws spell out. How officers are elected or appointed. Now, I will tell you that in Florida, most of the time, not all, but most of the time, your officers are elected by the board. The board of directors is elected by the owners, and only the owners can fire a board member or remove somebody from the board. And there's a process for that. And the officers are elected by the board of directors, and the officers serve at the pleasure of the board of directors. So when the board votes to make me president, I'm the president, and if they don't like how I'm doing my job, easy enough. All one has to do is make a motion to remove me from the presidency, get a second, and get enough votes for the motion to carry, and I am removed. I would still be on the board if I was a board member, but I would be removed from office. It's really that simple. Probably the #1 call I get from people in associations that we don't manage is, our president's decided he doesn't need to do what we tell him to do. He's become an autocratic dictator. How do we get rid of him? And I always go through this story. I say the president serves at the pleasure of the board of directors. So all you have to do is make a motion to remove the president, get a second, and get enough votes to carry it. They call me back after the meeting. I say, did you do that? No, nobody made the motion, because the problem is you have to be willing to make the motion sitting face to face across from the president or whoever you're trying to remove. But it is a simple process. There is no president for life, or I got the most votes, or treasurer for life. Your bylaws also spell out how meetings are called. So some bylaws set up a regular meeting. Other bylaws have the secretary call them. Other bylaws have the president can call a meeting with the consent of X number of directors, or regular meetings. But your bylaws may say how that's done. Your bylaws will typically say the term of the board member. Now I have to insert here, Florida law recently changed. While you can have 2-year and 1-year terms, beginning after I believe it's 2019, you can only serve 8 years on the board unless nobody else is willing to serve. There's a term limit of 8 years, then you have to take a year off, or you have to be elected by a supermajority, or nobody else has to run. So we're not going to have life tenures anymore in Florida. The condominium documents, not a lot of you were with condos, but the condominium documents, they set the basic rules. They define who's responsible for what. Who's responsible for the pipe in the wall that bursts? If the pipe serves my unit, am I responsible, or because it's in the wall is the association responsible? Who's responsible for the windows if they're damaged, and the doors? All of those kinds of things are covered in the condominium docs. So it tells you who's responsible for what. They also contain who's responsible for certain maintenance and assessments and how those are done, and the responsibility of owners to pay. They define unit owner rights. So what are the rights of a unit owner? Much of that is defined in the condominium docs. And they defined association responsibility. What is the association responsible to take care of? As well as they designate the common areas, the limited common areas, and the areas that belong to each owner. That's all designated in your condominium documents. HOAs. This is in the Declaration of Covenants and Restrictions. So is the right of way yours? Is the right of way the association? Who's got to cut the grass? Do I have to cut the grass in my backyard? I have HOAs where the association's responsible for all the lawns, and I've got HOAs where the association is only responsible for certain common lawns like entrances and such. All that stuff is going to be spelled out. Does the association have the right to limit the colors you can paint your home or approve things? All of that's going to be in it, and it's an encumbrance upon your deed. So if I want to know, can I put a treehouse in my backyard, I'm going to have to look at the covenants and restrictions to see whether I need approval of the board, whether I'm prohibited, or whether I don't have anybody that rules over me. Okay, policies. Typically, policies are written to help clarify things that are in your governing documents based on the authority given in your governing documents. A policy gives instructions to management. For example, your governing documents say that the board of directors is responsible and has the authority to collect delinquent accounts and may do what's necessary to collect from owners that don't pay. Well, your board may create a policy rather than looking at each account to your management company that says the management company is hereby instructed to turn over any delinquent account that is 60 days or more past due to the legal firm of the association for collection action. Now, every time an account hits the 60 days, it would automatically be turned over to legal for collection. We wouldn't have to have a meeting and discuss, we like Mrs. Jones, we know she doesn't pay, but she's a nice lady. We don't like Mr. Smith, he's nasty, and every time he gets behind, we would be treating everybody equally. And we've set up a policy to handle our responsibility as a board to collect the money that is due to the association. Policies also clarify things that are in the documents for officers and for board members and for managers. They can create instructions to the managers. We're going to instruct you that this is the way we want this handled. We want expenditures of more than X number of dollars submitted to the board for approval before the contract is signed or the vendor is hired. That might be a policy. They can limit the scope of officers. So I had a president in a condo who everybody on the board loved. He was a great guy, but he was a bit of a spendthrift. And his theory was when the board's not in session, he was in charge. So whether it was $10,000 worth of lawn furniture for the pool or a $50,000 sign, didn't care. He wanted to order those things. And the board finally came up with a policy that said that in the absence of a board meeting, the president's authority to approve items was limited to $1,000. So now he couldn't go out and sign for all these things that then he came to the board afterward and say, look what I did. So they came up with a policy that limited his authority to spend money and let him do everything else. So policies can be used for all sorts of things. Rules are more aimed at the owners. Rules clarify what's in the document. You must have authority in the governing documents to make a rule, but they make them easier to understand. I spend a lot of time talking about rules with people because sometimes we want to create War and Peace, the rules edition. And rules really should be simple, they should be necessary, and they should be enforceable. But they define and clarify what's in the document. So if the governing documents said that the association shall allow pets subject to restrictions set by the board of directors, we could have a rule that said you're only allowed to have one pet, that all pets must be under 35 pounds, that if you have a pet, you have to have insurance for your pet. And those are the kind of rules the board could make because they're given the authority. If the governing documents are absolutely silent on pets and they don't say anything about pets, they're allowed, they're not allowed, then the board can't make any rules about pets. And if the governing documents say no pets of any kind are permitted on the association property, then regardless, the board cannot make rules saying, well, it can be a 35-pound pet, it can be a bird, only pet alligators. The board doesn't have the right to do that because the documents spell out that no pets are permitted. And the only ones that can change the documents are the owners through the amendment process and a vote. The board doesn't have the authority. Those governing documents are the agreement between the association and the owners when they purchase, and to change that agreement requires the owners to agree to the change. So the rules are a roadmap. And I'm going to give you the last piece of my rules story. Drones have been running around the sky. Maybe they're not at your association, but they've been at some of mine. And all of the lawyers that I work with are really big on we should enact drone rules for all of our associations. Of course, that's not a standard set of drone rules. That's the, we'll draft drone rules for you. And I have been fighting that we're not going to have drone rules because Broward County and Palm Beach County will not let me mount anti-aircraft guns on top of our associations, so I don't have any way of enforcing the drone rules. I don't know where the drones come from, and we don't need a rule that they're going to call the board and the managers and ask us to do something about that we can't. Now, boards say to me all the time, what happens if somebody flies a drone over the pool and they're looking at the pool? And my answer is, if you're not doing anything you're not supposed to be in the pool, probably not a problem. Well, what happens if somebody flies a drone up to my window? That's why we have this thing called drapes, folks. You as a board member do not want to get into the drone enforcement business, and you should think about those types of things when you're creating rules. Is there a way for us to enforce this? Is it necessary? Are we given authority by the governing documents? All those things need to come together properly. Welcome to the board of directors. I often say when people tell me they've been elected to the board that much like owning a boat, the best day is the first day and the last. But you know, my condolences to you that got those of you that got talked into this. It is a lot of work and a lot of responsibility. So you're now on the board of directors, and the first thing you need to know is that all board members are created equal. I've been on the board for 5 years. I think I know everything. That doesn't mean I have more vote or more power or more say than you have. You got here elected yesterday. All directors are equal. They have equal authority. Their authority as a director is to go to a board meeting and to vote and to make motions. It's not to run day-to-day operations. Board members properly act at board of directors meetings. If you're running around your association saying, I'm on the board, I can decide whether you get to park there. I'm on the board, I can decide what we're going to do, what we're going to buy. You do not have that authority as a director, okay, and should be very careful, because your D&O insurance could claim that you're not covered as a director because you acted outside of your authority. So it's important to understand just what your authority is as a board member, and that's to go to board meetings, to vote on motions, to make motions, and to speak at board meetings, but it's not to act outside of the board meeting. Directors only can act at board meetings. That's very important. The board of directors, Florida requires nonprofits. We go back to 617, must have a minimum of 3 directors at all time. If you have less than 3 directors, your association could be forced into receivership. So if somebody resigns and you only had 3, the 2 remaining board members need to get on the stick and appoint somebody to fill the remainder of that term, so that you will be in compliance with the nonprofit regs that deem that an association cannot have less than 3 directors. You can certainly have more. What you can't have is less. Between elections, if a board member leaves, the remaining board members can fill that slot. Once they fill that slot, once they make a motion to put somebody on the board, there is a vote. That vote carries and that person is on the board. That new board member has the same authority all the other board members do. Okay? The fact that they were appointed doesn't change that they are absolutely equal to all of the other board members. Officers. Your officers are elected typically by the board of directors. They are not elected in secret meetings. We do not allow secret meetings in Florida, with a couple of notable exceptions, and I'll talk about those later. Okay, we had the owners meeting. We're going to have a board meeting. We're going to decide who's going to be the president, the secretary, the treasurer. That meeting has to be open to all owners, but they are elected by the board of directors. They serve at the pleasure of the board of directors. So when the board of directors hires you, the board of directors can fire you. It's that simple. The officers are the ones that oversee the day-to-day operations. If your association does not have a manager or management company, the president would typically oversee day-to-day operations, and the treasurer would oversee the financial operations day to day. The secretary would maintain the records. Okay, if you have a manager, those officers are going to instruct the manager or management company when there is not a board meeting to set a policy in process. The officers are charged with implementing. They don't set policies, they don't set procedures, they implement and follow the policies and procedures of the board. So just remember, two hats. I voted as a board member. The vote didn't go my way. I'm the president. I still have to, even if I don't like how the vote came out, I still have to implement the policies that the board voted on and approved, not what I necessarily want to do. All of the officers report to the board of directors. So often in board meetings, one of the things we always call for is officers' reports. You've probably heard this at your board meeting. We have an officers' report, treasurer, president. Maybe there's a gardening committee that we're going to have report. The reason that we're asking for those reports is because those officers are reporting back to their bosses, who is the board of directors. It's the board of directors that gets to oversee and make final decisions. Okay, basic officers you're typically required. You need a president. The president implements the decisions. They oversee the day-to-day the manager on a day-to-day basis. They answer questions in absence of a board meeting. They may manage the association in absence of a manager, but they cannot be paid as a board member to do these duties. They can't be, the association can't hire them to manage the association. That would be a conflict. You can't serve on the board and also be a paid employee of the board. Treasurer oversees the financial matters, including payments and collection from owners. So it's important we have a treasurer and a secretary who oversees all the official records, the minutes. You have a manager. They may help these people with this. They maintain the records, but the secretary would have authority over those records. The treasurer would have authority over financial decisions in absence of the board meeting. So we got everybody going here. We're now ready for a board meeting, right? Right. Okay. Everybody here that has been to a board meeting, raise their hand. Trying to make sure that everybody isn't asleep. Great. Okay, so you've seen board meetings. Did you know that a regular board meeting must be properly noticed no less than 48 hours in advance of the meeting? In addition to properly noticed, being posted where the association says it's going to post it, the individual board members must be notified. Now, that can be done by email, by calling them on the phone, but I'm in New York. I can't be relied on that I'm going to come see the bulletin board in South Florida. You have to actually notify the directors. Owners can be relied on to look at the bulletin board. 48 hours in advance. We're just coming out of emergency operations from the governor, and that kind of waived this 48-hour rule when it came to emergencies for boards. So we've been doing a lot of Zoom meetings for boards because we don't want people to conjugate, get them all in a meeting room. And the emergency powers allowed us to do that. If you're going to have a budget meeting, which you are required to do annually, okay, you have to give the owners at least 14 days notice prior to the budget meeting. And you must send them a copy of the proposed budget. Doesn't have to be the budget that ends up being enacted, but they are entitled to get with their notice, and this has to be mailed. It can't just be posted, or it can be emailed if they have agreed to receive official notice from your association by email. You must provide them with a copy of the budget meeting notice and a copy of the proposed budget 14 days prior to the meeting. If you're going to have a meeting to make a change of rules, again, you have to provide 14-day notice, and you have to provide the owners with copies of the proposed changes to the rules with that 14-day notice. They want to show, The board decides on the rules, but owners are entitled to come and speak on anything that's on the agenda. And a change in rules usually gets a lot of owners to show up. Special assessment meetings, they must be properly noticed, no less than 14 days prior. Again, mail or email if they've agreed. It must include what the special assessment's for, how much is proposed, not the end, but how much we're proposing to have as a special assessment, and how the money is subject to be used under this. Okay, and once you approve a special assessment, you can't change how you use the money from what you told people. All right, so proper notice includes the date, the time, the location of the meeting. Emergency meetings don't need the 48-hour notice, and the recent stay-at-home order, as I told you, we've been doing a lot of meetings over Zoom, and which we can do, and we can still let owners participate just like you're getting to ask questions. The emergency order has come to an end, and we're going to see how that goes. We'll probably continue Zoom with our meetings, but we'll also make them available in a meeting room if people want to come and speak. But people don't all want to get together yet, it seems. So, official records of the association, and I ask this all the time. The first thing is, who do the official records belong to? We're a management company. We have a lot of official records for associations. Do they belong to us as the manager? Do the official records belong to the board members that are in place that have gathered them up? Well, the official records belong to the association. And you must, if you're a board member, you have to pass them on to the next board if you have access and have the records. As a management company, we must pass the records on. If somebody replaces us, hires another management company, we have to pass the records on to the new management company. When we get an association that has been managed by somebody else, we notify them that they have to pass the records on to us. But the records do not belong to the keeper. The records belong to the association. Official records are subject to inspection by the owners. So if you're an owner and you want to see the official records of the association, you are entitled to do that. And the records that are entitled to inspection are listed here. They include everything from the developer's documents to the current rules and regs to the minutes. It used to be you only had to keep minutes for 7 years. Beginning in July of 2018, associations must keep minutes continuously forever. Now, you don't have to go back more than 7 years before 2018. So 2011, you have to have your minutes going forward from. Okay? Rosters and voting certificates, insurance policies, all the contracts, bill of sale, all of this information. You need to keep the ballots for 1 year till the next election has been completed. Okay? Any rental records, rental of association property, all this information needs to not only be kept, but it needs to be available for owners' inspections, along with financial records of the association. There are records that don't need to be, so they can look at the financial records, they can look at the bills, the invoices, the contracts, okay? But owners are not entitled to see any records that were prepared at the direction of the association attorney and that are attorney-client privileged. Certain information obtained by the association in connection with approving a lease or purchase or sale. Things like driver's license information, credit reports, social security numbers, that type of information is private and does not have to be shared. Personnel records of the association or management company don't have to be shared. Medical records of any owner. So we recently, this happens all the time, we recently had another owner. They wanted a service animal. They provided because it was not an apparent reason, they provided the association with information to their disability. The association granted them the service animal. We didn't have any choice there. And owners come up to us and say, how come unit XYZ has a dog? And all we can say is it was granted under HUD and the Americans with Disabilities Act, And, well, what's their disability? We cannot comment on any medical information that that owner shared with us, and we won't. Okay? That is private. So you might have gotten it for an animal, or I had somebody recently that wanted all of the knobs on all the doors, which are owned by the associations, are door knobs, and this person has severe arthritis, and they wanted a lever door. And the board started out by saying when they asked for it, no, you can't change it. We want them all to be knobs. They all look the same. And when they submitted a medical request based on their disability, the board approved it, but we can't discuss the disability with other owners. All we can say is they were granted an exemption under HUD and ADA rules. Okay, social security numbers, driver's license numbers, electronic security measures, you get the idea. The association software and its passwords are not something that we have to share. Records inspections. So all of your records have to be available within 45 miles of your association. Now, if the records are available online, and you can sit in a computer in your living room and see them, that's within 45 miles, by the way. Okay, the records have to be made available. It used to be 5 working days. That was just changed to 10. You have 10 days from the time somebody makes a request to make the records available. In our case, we make everything available online, so that's really not an issue. But when somebody wants to come in and see records, you have 10 days to provide them with access, set up the appointment for you and for them. But it is important that you do that because that is one of the things the division is fairly serious about, and they will do enforcement, and they will penalize your association if you don't meet the requirements to make records available. Okay? You can have a copy of the official records available for inspection at the association office, your manager, or you can do it, say, we image everything, all of our records are available in a web portal. Owners can look at them at home in their pajamas, and that meets the requirements as well. Okay, so inspection requests, okay, they need to be reasonable. You can't keep asking for the same records over and over again. Association can adopt rules, so the board can adopt rules that say that you can only make a request for records once, that you're only entitled to do a records request and come in once per month. So they can limit that if it becomes a pain. Owners are permitted to make copies of any records they want, including to use their cell phone cameras to make the copies. The law specifically allows cell phone cameras and pictures of the records. Otherwise, you have to provide copies at a reasonable cost. Okay, if you deny access, can be a $50 per calendar day penalty, not to exceed $500 unless you do it again and again. You don't want to deny access. Let people see the records they want to see, because trust me, if you don't, they'll make up something that suits their imagination of, that doesn't meet the reality of what the records are. There's no reason not to. We've never got in trouble letting people see records, but you do need to make them available. If you have more than 150 units, or 150 or more, you need to make your records available online on some kind of a secure website that owners can log into. Okay, that website can be a website you purchase from a third party. It can be a website your management company provides. It can be a website you provide, but it has to have some kind of secure access to the records, and you must have this website. Now, believe me, we provide a website for all of our associations from 10 units to 1,000. It's a much better deal than having people show up and sit around the office going through records, and it just makes your life much easier. So certainly if you don't have a website, you may want to consider it. Great. Oh, just about halfway through, and we're going to talk about financial reporting requirements. Now, we're going to talk about the requirements mandated by the state of Florida. This does not mean that it's all you should do. The state requires annual reporting, but you should be requiring from your manager or your treasurer some kind of monthly reporting, because by the time the year is over, the cow has already left the barn with the lantern kicked over. So, I grew up in Chicago, and we all remember Mrs. O'Leary's cow. You don't want to let that happen. You really should be looking at your financials every month. And while the treasurer is responsible for the financial communication, if you sit on a board of directors, every member of the board should be looking at the financial statements and should raise questions if they don't understand something. It's not just up to the treasurer. If you're sitting on the board of directors and there's something on those financial statements or something going on that doesn't make sense to you, you should raise a question, and your manager, your treasurer, your accountants, somebody that's responsible for putting that information together should be able to answer those questions for you. If they can't, that means that you have a problem. Annual financial reports. Now this year, this all got suspended out because of COVID-19, but they're supposed to be ready within 90 days of the end of the association's fiscal year. What you prepare depends on the total financial activity you had. 21 days after they're prepared, after that, they need to be completed, but no more than 120 days from the end of the year, except this year because of the emergency orders, which told this. We're now back to where we've got to get them out. 120 days from the end of the fiscal year, you've got to be able to provide copies of these financial statements to all of the owners. You can hand deliver copies, you can email copies, or alternatively, you can send out a postcard that says the financial statements are ready and available for owners, and if you make a request, then we'll email them, and that's what we do. If we sent them all out, we'd just be killing a lot of trees and spending a lot of money on postage. A lot wouldn't get open. So we send everybody the postcard and an email telling them that they can get them on our web portal for free. They can call us or email us, and we'll be happy to email them a set. They can stop by our office, and we'll be happy to print and give them a set, or they can request we mail them a set, and we'll be happy to mail it to them. But we have to provide them when they're requested, and we have to let people know they're ready to be provided, and so do you, even if you're self-managed. So, if there's 10 units, you might just want to hand them out. But if you've got a lot more, what I'm going to tell you is, people used to bring them to meetings still in the envelopes and say, I don't know why you sent me this stuff. So that's why we're doing it, okay? You have to send them within 5 days of when the owner requests them, and buyers are entitled to a copy of the annual financial statements when they purchase. So if I'm purchasing in your association, I'm entitled to see a copy of the annual financial statements before I purchase. That copy should be provided by the person that is selling. Doesn't have to be provided by your association. It can be provided by your association for a small charge if they want that. If they want it for free, they should go to the seller. It is their responsibility, just like it's the seller's responsibility to provide a copy of the governing documents to the buyer of your unit. Financial statements are part of the official records, so they stay forever now, and they need to be of the form approved by the division. Copies of the financial statements must be maintained and available at a reasonable cost. Copies must be provided to purchasers. I've told you this, but it's not something that doesn't bear repeating. Financial statements required to be prepared depend on the revenue. So how much was the revenue of your association? That's going to tell you. An association with total annual revenue of less than $150,000 can prepare a cash receipts and expenditures report. Pretty simple. Doesn't have to be accrual, doesn't have to be compiled. Probably not the best representation, but it's simple. If an association has more than $150,000 and less than $300,000 in annual revenue, they must provide compiled statements with the appropriate disclosures. If the association has a total of more than 300, but less than 500, they must hire an independent CPA to review the financial statements. Now, a review isn't an audit. It's kind of a less thorough check. And if you're over $500,000, you must prepare audited financial statements. However, there is nothing preventing an association with only $100,000 worth of revenue of getting a compiled statement. You can always do more than is required. It takes a little more. You generally can't do less. Documents required for an audit and review regardless. Okay, so you have to go to your governing documents. Your governing documents could say, I just ran into a fairly small association where they have to get an audit, even though they only have $200,000 worth of revenue, because the governing documents require the association to provide the owners audited financials on an annual basis. And unless the owners vote to amend those governing documents, the governing documents rule, not the state statute, because the governing documents require more, not less, than the state statute. What's included in annual revenues? Interesting story. So we have a little association, never had over $200,000 in revenue, but during the height of the downturn, they bought a unit back. And last year, they sold that unit that they've owned for the last 9 years, and they sold that unit for $500,000. Now, they paid $250,000 for it, so they made $250,000 in profit, which would still have them, if we only counted the profit, as the president argued, that means $250,000 in profit plus the $200,000, we're at $450,000. Only the statutes don't say that. They say the total gross revenue. So they sold it for $500,000. That automatically meant they now had to have an audit for that year. A few years ago, after one of the hurricanes, I had an association that got $500,000 for a roof that was destroyed. And that association, who normally only needed a review, now met the definition of what was required for an audit, and they had to get audited statements. And their argument was, but it's our money, it's our insurance money. The state specifically defines this revenue number as including regular assessments, special assessments, interest income, late fees collected, insurance, fines, and penalties. Everything that you deposit in your bank account counts here, other than money you borrow. So it's important that you know that you can end up having to do an audit. Your manager or your accountant should be able to determine fairly easily when an audit is required and let you know that. You can always get more extensive reporting. If you're only required to have cash receipts, you can go to compiled, reviewed, even audited. Okay, it's easy to do. All your board has to decide is they want something that puts a little more teeth in it, and they can do that. You can waive this requirement, but you must do it before the end of the year, and you can only do it, you can only go down one step, and you can only do it 2 of 3 years. So not something I would advise, but you decide, your owners decide they don't want to pay for an audit this year. We vote to waive the audit. We do it before the end of the year. We can now have a review. Okay? Not really a great idea to do a waiver and get something less than is required, because after all, the audited financials help protect you, the board. What they do is tell the owners that these financial statements aren't our opinion. They're not our manager's opinion. They are the opinion, after serious review, of an independent certified public accountant that has gone through our records and looked at them. So always nice to have, an expert on your side, especially when somebody gives you grief about the financial statements. Florida law does not allow associations to have debit cards. If I had my way, they did this a few years ago. They'd also wouldn't allow credit cards for associations, but debit cards, the state found, was the #1 thing used for fraud by association boards, managers, maintenance people, everybody, that it just money came out of your account and you didn't know. So they have prohibited associations from having debit cards. I'd like to see them do the same thing for credit cards. Then we could just do straight reimbursements, but that hasn't happened yet. For those of you that have been dealing with the COVID-19, which has seriously affected lots of associations, how we hold our meetings, what we do, we have put a lot of information on our website, which is www.royale management.com. If you look, there's a little red thing here at the top. Click on that, and it has the latest COVID-19 information that we've been collecting and links to emergency orders and all sorts of things going on. We will continue to update that until they give us all the shot and it's over with. Many of you will still find your pools are closed. The county has made it, at least Broward County, Palm Beach too, to an extent, have made it difficult. Yes, you can open pools, but it is very expensive. They want attendance. There's other rules. Attorneys have often advised that if you mess up on any of these measures and you're sued, that your insurance probably won't protect the association, and many of the associations we manage have chosen to keep their pools closed until it gets a little easier to go back to the point of opening pools, and we don't have to have pool attendants wiping things down and watching that nobody gathers too close together, and all these other rules that have come in. We have a lot of information on that, including this emergency order on our site, and it's still in place. And Broward still has a number of rules, but I suggest if you're one of the people crying for the pool to be open, or you're listening to owners cry for the pool to be open, that you take a look at more information on that and talk to your attorney about the liability of moving forward and opening the pool and not being able to do all the stuff you're supposed to do. We've been doing a lot of our meetings through social distancing with Zoom, just like we're doing this meeting. This is our second board certification through Zoom. We have a really nice classroom here, and we love seeing all your smiling faces sitting in the classroom. Would love to have everybody back here, but we're trying to protect everybody, so we've gone to these Zoom meetings. And you can think about how you're going to be handling board meetings. As I say, we're doing a lot of board meetings as Zoom meetings. With the end of the emergency, we're probably going to need to let people sit in our classroom, but board members don't have to be there. We can just put a camera and let anybody that shows up also be able to speak there. All right, so, and if you are interested, we've done some updates on that, so you can go on our website and sign up for newsletters. There's information on the board emergency powers. I'm not going to spend a lot of time because this is kind of coming to an end, but we will talk about budgets, maintenance fees, and reserves. So you are required to construct a budget annually. You don't want to say, I picked up an association to manage, and they said, we haven't done a budget in 10 years. We just do same as last year. And well, you have two problems. One is, I'm really concerned that none of your expenses have changed over 10 years. What that tells me is 10 years ago, somebody was collecting way too much money for a whole bunch of years, and it ought to be, socked in a bank somewhere. Or you have been cutting back on the required maintenance of the building, and stuff has not been taken care of, and this place is going to start to fall apart. And because the cost of things is not the same as it was 10 years ago. More important than that, if somebody isn't paying their maintenance fees and you haven't gone through the exercise of creating and approving a budget, your governing docs give you the right to collect maintenance fees based on the approved budget. And I have seen in court where an owner that wasn't paying made the claim to the court that he wasn't paying because he didn't owe anything, as the association had never approved a budget. And the judge determined he didn't owe anything because the governing docs state that he has to pay X% of the amount, the annual budget amount approved by the board of directors. And if the board didn't approve a budget, and we don't have minutes, and we don't have the whole budget meeting thing, then obviously he could stay there for free. So budgets are important. If it comes out the same as last year, maybe we found savings, maybe we did some. I'm okay with that as long as you went and did your homework. But just going, oh, we're not going to make any changes, they just keep paying the same amount. You do not have a right to do that and collect. You are required to construct and approve, go through the approval process, a budget annually. Your budget is required to include reserves. Even if your members vote no reserves every year, not a good thing to do, but even if they vote no reserves, how can they vote no reserves if they don't know what the reserves should be? And how can I be expected to buy a unit if I don't know that you've got a $500,000 roof replacement that's 3 years away and you've put away no money? I have a right to know that when I get the financial statements and the budgets and the reserve. So if the reserve budget shows $500,000 new roof coming 3 years from now, no money in the bank, that might affect my purchase decision, or at least how I valued the unit I was buying. I'm going to get back to the rest of the questions towards the end. So trust me, I will put them in there. Condos must have reserves. Co-ops must have reserves. Okay, the reserves can only be waived by a vote of the owners, and that vote must be done annually. Because they waived the reserves 5 years ago does not mean the reserves are waived today. Every year there has to be a vote of the owners to waive reserves if they want to do that. If the owners want to partially fund reserves, there has to be a vote. Your obligation as a board of directors under the law is to fully fund the reserves as required unless the owners vote to reduce that funding or waive it. The numbers for your reserves shouldn't just be based on a guess. They should be based on some kind of outside expert. So they could be based on a reserve study. I could certainly get my roofing reserve number from a roofing contractor, get him to go up, look at my roof, tell me what the replacement cost was going to be, tell me how much longer it's going to be till I have to replace it. That would give me my roofing reserve. I could do the same with a paving contractor, but it's not just supposed to be, as a manager, I'm not qualified to say what the new roof is going to cost or how long the roof is going to last. That's supposed to be somebody with expertise, okay? And there are plenty of people out there that will be happy to do that. HOAs are not required to have reserves, but if they have established reserves, so once they set up reserves in a reserve account, they must keep funding it unless the owners vote to waive, and they cannot remove the reserves without the owners voting to relinquish or get rid of the reserves. The owners can vote to do that, not the board of directors. So why would an HOA want reserves? Well, I've got one right now that the concrete wall around the outside has got some issues and starting to lean over, and it's going to need to be replaced because it wasn't taken care of. I have another association that's an HOA, but they have a pool and pool house. Pool house is going to need a roof at some point. The pool is going to need remarciting and redecking at some point. So they might want to have reserves for those things. So component reserves, really easy. Florida says that I must have, for a condo, a roof, a painting, and a paving reserve. However, anything that's going to be a major item, I can put on the reserves, especially if it's going to affect the ability to occupy the unit. So I typically I'm not looking to put floor tile on the reserves. I'm not looking to put canopies and awnings or cameras, but windows. I've got a high rise on the beach. We're going to have to replace the windows at some point. We know there's about 12 years that we're going to have to do that. We're going to have to put in hurricane windows. We've looked at that. We're reserving money for that. So good idea. Elevator replacement or refurbishment. Apparently elevators now only last 25 to 30 years. I was recently at the Peabody Hotel in Memphis, and they're still running the elevators they ran 100 years ago. And, so they're not built the same as they were 100 years ago is what they tell me. But those are the kind of things we can't keep the building up. We can't have occupancy in a building without an elevator. You might want to put that into the reserves. So if you look here, we have a roof reserve. We were told that this roof had a 25-year useful life. When we had it evaluated, The roofer said there's about 7 years remaining on that useful life, and that it's going to cost $200,000 for a new replacement roof in today's dollars. We already have $100,000 in our fund, in our reserve balance that we've collected in prior years. We need to collect another $100,000. If we divide that $100,000 we need by the 7 years we've got to collect it, we need to collect this year $14,286. That's from all of the unit owners, and we'll figure out the unit owners after painting and so on. So we need to collect $65,595 total. This association, the documents say there are 100 units, and the documents say that each unit owner pays an equal share. So we're going to collect $6,560 this year from each unit owner. Okay? Your governing docs specify how expenses are allocated. If the governing docs say 100 units, everybody pays equally, great. Other governing docs may say 2-bedroom units pay X percent, 1-bedroom units pay Y percent. Other governing docs cover each unit or each stack. Whatever the governing docs say. I have a gentleman that was in here 2 weeks ago. He was very upset. He's determined that he owns one of 2 1-bedroom units that are in his association, and he pays the same as all the people with the 2-bedroom units and the couple of people with 3-bedroom units, and he thinks that's unfair. And I agree, it's unfair, but as I used to tell the kids, a fair is a place that you ride rides and win prizes. Life is unfair. Get used to it. When he bought, the governing doc said that everybody paid an equal share. He agreed to that when he bought into the association. That's the deal. It can't be changed because he feels it's unfair, and the only way to amend it would be to get all of the unit owners to vote. And what do you think the chances of the 3-bedroom unit owners and the 2-bedroom unit owners voting so that they can pay a higher share? Somewhere between slim and none. Okay? So it's important to understand how these things work. Reserve funds that are collected cannot be commingled with operating. Now, we all know you're going to write one check for reserve and operating, but within 30 days, you have to take the reserve portion of the money you collect and move it from the operating account to the reserve account. It is not supposed to be commingled or mixed with your operating funds. That's because you can't use it for operating. Okay? Reserve funds can only be used for the items they've been reserved for. The only way to change that, I have money in the roof and I don't need it right now, but I need pool money. Only the owners, not the board of directors, can vote to take money from one reserve account, move it to another reserve item, or to take money from reserves and move it to operating. The board cannot use reserve money for anything but what it's been designated for. All right. Typically, when we vote on these things in anything but the election of directors, we use a limited proxy. The reason we use a limited proxy is because if we don't get enough people and enough participation, a limited proxy is good for 90 days. We can table the count, we can go out and knock on doors, and we can try and get the proxies that we're missing. So whether we're amending documents, whether we're voting to waive reserves or to make reserves a smaller amount, to limit the amount of reserves, or to change a reserve item to another reserve item, we like to vote for these things using limited proxies, not ballots. You can use both, but if you use ballots and the election doesn't go, you don't get enough information, you don't get enough ballots, when you go to fix it, you're starting over from scratch. Using a limited proxy is just a really good way to do this. Okay, maintenance assessments are determined by taking the budget and multiplying by whatever it says in the governing documents. I've covered this, but it's not up to the board to decide. I recently had a board member tell me that he didn't like the way that they were associated because he lived on the ground floor and thought he shouldn't have to pay a percentage of the elevators. That's not how it works. You moved in here, it's equal. Here's the way that it works. Everybody pays for the roof from the top floor to the ground floor. Everybody pays for the elevator. Everybody pays for the pool, even if you never go in it. All those things are covered in your governing documents. Reserves are calculated the same way based on the same formulas. So everybody's usually waiting around for the enforcement section. Who's here that wants to know more about enforcement? How do we get people to do stuff? Everybody wants to know about enforcement. First thing that happens usually when we get hired as a manager is the board of directors or president come to me and they say, we have these people that won't comply. How are you going to make them do X? Sorry, they did not issue us guns, badges, or billy clubs when they issued our manager's license. So, unfortunately, our power is to send a certified letter. So we can send a violation, we can send a certified letter, and then we can send another certified letter. And if that doesn't work, it's time to go to legal counsel. But you need to make sure that you're enforcing your declaration equally across the board. I once had a association treasurer call me to complain that somebody had rented with a dog and they only allow dogs if you were grandfathered in, while his dog was barking in the background. Well, the dog would have had to been 35 years old to be grandfathered in, and he hadn't bought the apartment until 4 years ago. So the fact the guy before him had a dog, and that dog had been grandfathered in when they voted to have no dogs, didn't do anything about his dog, and I unfortunately had to send violation notices to him and to the person that was renting with the dog and to everybody that I was aware of with dogs. I can't just decide I don't like your dog, but I like somebody else's. We have to enforce the rules equally. We cannot, you lose your right to enforce rules if you selectively enforce them. So it's really important that you can show that you've made an equal effort to enforce the rules against everybody. Okay? So you have an obligation to do that. A failure to enforce the rules means you could lose the right to enforce a rule. So if you're letting dogs live in the building that has a no pet rule, not ESA animals, but just pets, and you've been letting them live there and nobody said anything about them, after a time certain, okay, the owners are going to argue that you've lost your right to enforce the pet rule. And it's complicated and requires work and money to reinstate that rule and to get it back there. And included in reinstating that rule is going to be those people that have dogs are going to get grandfathered in and get to keep them when you reinstate the rule. So it's important not to let rules lapse or ignore the enforcement of your rules. You don't want unit owners claiming selective enforcement. You don't want them to claim that you've lost the right to enforce a rule, and you certainly don't want them to claim a breach of your fiduciary responsibility because you're picking on me, but the rules aren't the same for you, and the rules aren't the same for Mrs. Jones across the way. As I told you, we can send a written violation. I'm going to tell you, my managers are forbidden from confronting anybody. They are not allowed to go knock on somebody's door and talk about violations. They're not allowed to call about violations. Okay? They can send a formal or informal written notice. Now, why do we feel that way? Well, in South Florida, the guy behind the door could have a shotgun or any other kind of gun, or just decide he's going to hurt you very badly. So as a board member, I recommend you don't knock on anybody's door and tell them they're violating the rule. They could also accuse you of discriminating against them, saying things that you didn't say. By making the violations written, it's very clear specifically what the violation is. What we've said is clear. There's no room for misunderstanding or saying to somebody, he said, she said, we said. We're very careful about that, and having a written violation policy that goes to owners will prevent a lot of problems, because sometimes people don't hear what you say to them. And it is not unheard of for somebody to be having a bad day and decide to take it out on the person that knocked on their door. And they don't pay you anything as a board member. I don't pay my managers enough that they want to be spending time in the hospital because they confronted somebody. If we need to have somebody confronted, that's what law enforcement is for. Call the police. Somebody's too loud and you want them to turn down the music, file a noise complaint with the police, have them come out and deal with it. Don't deal with it on your own. Don't stop people in the hallway. Don't accuse people of stuff at the pool. Be cognizant of the world is full of crazies and you don't want to be the subject of some crazy's rage. The good news here is that 95% of the people we send violation notices out to correct the problem. They either didn't understand the rule, they didn't know about it, somebody did something, and they're very nice. We get a note back, we get something that says, I know it's no pets, I didn't know my mother was bringing her dog, we won't let her do that again, and they take care of it. Unfortunately, 5% of the people that you're dealing with should be living in a cabin in Montana, at least 500 miles from civilization and roads, because they agreed when they bought into your association to be bound by the rules, and they signed off on the rules and the governing documents, and they just don't play well with others, and they think, I bought in here, now I can do whatever I want to do, and you're going to have to make me. And make me is a job for your attorney. If you don't use your attorney to deal with these people, what's probably going to happen is word's going to get out and the 5% is going to grow. So I'm suggesting that when you can't get somebody to comply, unfortunately, it's expensive to use the legal process, but the only thing more expensive than using the legal process is to ignore it because it will only get worse. Fines. Now, you are permitted to have fines if you have a fining policy and a fining committee. I don't like fines because while you can assess them, you can't foreclose, lien to collect them. So if somebody doesn't care about the rules, they're not going to care about your fine because they're not going to pay it. And the only time you can do anything about it is when they get ready to move. And when they get ready to move, you can put on their estoppel, oh, he owes me $1,000 in fines. I once had a board do that, and we had $1,000 in fines, and the guy who was a real thorn in their side and had a buyer and was leaving said, well, if I have to pay the fine, I just won't sell my unit. And the board reconsidered, smartly so, and said, it only costs us $1,000. Never have to deal with this SOB again. We'll waive the fine on the estoppel. If he hadn't said anything and it had been paid at closing, we'd be fine. But fines are really not a great way to get compliance. It requires you to have a fining committee, which cannot be anybody that lives in a board of directors with the board of directors member in their home. They have to be independent. Or the fining committee can only either uphold the fine or waive the fine. And, we got to find some brave souls that are going to put up with the people that are going to be living next door to them who they're going to say, you have to pay the fine or else. My suggestion is skip the fining and go to legal. It's much cleaner and easier, a little more expensive, but fines are not really a great way to do something. I've pretty much talked about what you have to do to have the right to fine. Other enforcement actions you can take, there's 3 forms. You can go to voluntary mediation with mediators provided by the division or through citizens dispute settlement centers. In voluntary mediation, it's they put a guy in the middle and he tries to get us all to agree. The mediator's job is to bring us together. If we agree, the agreement is binding, and if we ignore it, then it can be enforced in court. So it's one of the benefits. You can go to mandatory non-binding arbitration. Arbitration's a little different than mediation. Arbitration, the person in the middle, the arbitrator, acts as a judge. They take our facts, they take the opposing side's facts, and they make a decision based on their belief of what's right. And then we have a choice of either agreeing to that decision. Again, if all parties agree, the decision, if either party doesn't hold to their agreement, is enforceable in court. But if all parties don't agree, then we just start over in court. And you can certainly file formal legal proceedings. Most of the time, the courts are going to make you go to the mandatory non-binding arbitration or the mediation before you can file a suit. And you can certainly do those things without your attorney, but I would recommend that you be represented by counsel at mediation or non-binding arbitration. So we've talked a lot about that. I'm going to give you these slides when we get to the end. We're down to the election. Most of you were elected, so that's a good thing. You weren't appointed. I just want to make a few points about elections, then I'm going to go to your questions. Okay, elections take place for an HOA. Elections for an HOA take place at the annual meeting. You have to send out a 14-day notice. It can be mailed, hand-delivered, or electronically if people have agreed to that. You need to have at least 30% of the members present in person or by proxy. If there's only 20% of the members present, the old board remains in place. You have to have at least 30% to have an election. If there's 31% and that's all that voted, the 31% makes the decision. So that works, but they have to be present in person or by proxy. Voice votes permitted for HOAs. The HOA law also does allow you to adopt, similar to the condos, a written voting and secret ballot thing, but they're not required. Okay, if you're ineligible, delinquent, obligate. If you're ineligible to vote, if you have delinquent obligations, and you cannot, to run for the board, have a felony conviction. Excuse me, you're ineligible for the board if you're delinquent in any of your obligations or have a felony conviction within 5 years. We don't want any felons unless they're old felons, I guess, on our boards. All right. Term limits that were enacted 7/1/2018 and amended 7/1/2019. No more than 8 consecutive years unless nobody else steps up. You can roll over if nobody steps up. You can put your name in if there are less people running than there are seats available. Then you would automatically be able to go on past the 8 years. If you're over the 8 years, you're not going to be listed on the ballot typically. And the 8 years started 7/1/19. Don't ask me. They've been playing with this off and on, but this is intended to get us some new blood. Now, the truth is the best boards are adding new blood all the time. So, you know, somebody comes onto the board, they're new, they get to sit on the board for a couple of years, maybe before they move into an office, learn how the board works. They might act as the vice president or so that they can learn the duties, but those type things. If you're in a condo, 2 notices to the unit owners. The first notice says, hey man, we're having an election coming up, and if you want to put your name in the hat, so to speak, if you want to submit your name, you need to fill out a form and give us your notice of intent to run for election, and you need to do that not less than 40 days before the election. So you have a first notice, we have an election coming up, you want to do this. Now, one of the dirty things in Florida condo politics has been management companies and or boards that somebody puts in a notice of intent to run for the board and they pretend they didn't get it. You have a right, if you put in a notice of intent to run for the board, you are supposed to receive a written acknowledgement that that notice of intent was received. I highly recommend that you do. When we get notices of intent, if they can come by email, we email back acknowledging we got it. If somebody drops one off here, and they do that all the time, we actually make a photocopy, stamp it received, and give it back to them. But we want them to have something that proves that their name needs to be on the ballot, because if when the ballot comes out it's not on there, it's too late to say, but I did put mine in. If you put in a notice of intent, you should be on the ballot. And the only way you can prove that is by having an acknowledgement. So it's important to get that. The second notice of the election is going to come out not more than 34 days before the election, and it's going to contain the ballots. and the balloting information and the inner and outer envelopes, and a brief you can include if you've decided to run. You can include a one-page 8.5 by 11 bio. Anything you want to say, your association is obligated to send that out with the second notice. I all the time get calls from people saying that, how did you let this go out? There's misspellings in it. How did you let this person say this? And the answer is, as a manager, when somebody gives me their bio information to go out, my obligation is to send out whatever they gave me. I am not supposed to edit it. I'm not supposed to comment on it. I'm not supposed to fix it for them. My job is just to make the copies and send out that notice. So if you write it in crayon, I'm going to send out written in crayon when I do that. It's nothing more than a photocopy. And I am always amazed. People say things that if I were the people they were talking about, I'd sue them. But, you know, things that you got to be careful what you put in writing. Notice of intent, I've told you, got to be in 40 days before. You want to have it in before that. You cannot be delinquent on any obligations. By the way, this includes fines. So it's the only place that if you owe a fine, nope, you didn't pay your fine, you cannot run for the board of directors. You can't have any felony convictions within the last 5 years and run for the board of directors. So it makes sense. People that owe your association money shouldn't be able to decide how the association spends its money. I've given you a whole bunch more information on candidates here and delinquencies, and you're going to get this. I am not going to go through it. Okay, the voting process, the ballots must list all candidates in alphabetical order. There's an inner envelope that must be placed inside an outer envelope that has to be signed by the voting member of the association and have the unit number on it. They have to be submitted before the count begins. I was just at an election, and there's a guy that's always looking to give the board grief, and he was sitting in the back of the room, and I was handling the election for them, and I announced when people came in, here's the ballot box. You need, if you have ballots, you need to cast them. When the election got ready to start, I announced before we open the ballot box and begin counting the ballots, if anybody has a ballot they have not submitted, they need to do so now, because once the ballot box is open, no further ballots will be accepted. We opened the ballot box. The appointed counters went through and counted. We were announcing the results, and the man stood up in the back of the room holding up 5 envelopes and said, wait a minute, I have 5 ballots here. That's going to change the results. And I said, no, I'm afraid it's not, because the ballots were not submitted before the ballot box was opened. So that's what the rules say. But you know, he thought he was going to get to plug in his numbers. The state of Florida has a very good brochure about elections. If you're not sure how elections go, the state can provide election monitors. If you have contested elections, I've worked with state election monitors. They do a really good job. They will slow the counting process down a little bit, but they do a really good job, and they bring with them people to make sure that everything is monitored. So if you have a contentious election, not a problem. Owners are permitted to watch the counters. We usually try to figure out, we put it in another room and say, you can go in here, just we don't want everybody talking while they're counting so that they lose count. But the counting process is open. Owners are permitted to observe it. And the counting, the people that verify the count can't live with a person that's running or a current board member, and you know, have to be willing to assist in verifying the counts. All right, so there were recent changes that cleaned up the voting rights, the 90-day suspension. You can't take somebody's voting rights away if they owe less than $1,000. There's a lot of other stuff on the Florida site. They've also recently made really clear about conflicts of interest, a situation in which a party has a duty to more than one person. So you can't be in conflicts, which means you can't hire your brother-in-law's company. You can't hire your kids, okay? You can't sell services to the association as a board member. It's important to understand what conflicts are. If you have a conflict, you need to disclose the conflict. You need to leave the meeting for the discussion, and you need to be recused from the vote. That can sometimes happen. you cannot provide any service. If you own a service provider, they can't provide service if you have any kind of relationship to them. So I can't be on the board or an officer and decide that I'm hiring my landscaping company, my sister's painting company, and my grandfather's concrete restoration company. Okay? You can't have those kind of relationships. Those are automatically conflict. New rules on estoppels that went into effect. The fee typically for an estoppel, the maximum fee is $250. They have to be produced within 10 days. You can add $100 if they want a rush fee, then it requires 3 days. Remember that typically the buyer pays for the estoppel, but if the buyer doesn't close, it needs to be refunded and it is charged to the seller. So I was going to buy your unit, I got an estoppel, I don't close for some reason, my money has to be refunded, and the cost of that estoppel can be charged to the unit seller. If it's illegal, you can get another $150 for having to send them over to legal for the estoppel. Just a reminder that whether you're a director, an officer, or manager, kickbacks, forgery related to voting, theft, and embezzlement are all considered criminal and have criminal penalties. Okay, some really good resources which will be available to you on the website I'm going to give you to get to these. Peter M. Dunbar has some great books. It's kind of like HOA or condo or co-op operations for dummies. He doesn't spend a lot of time discussing the reason behind the law. It's a lot of if A, B, and C are correct, then D works, or if you don't, or how many days. It's really a great guidebook, and I suggest that anybody that's on a condo board or an HOA board get one. All of my managers get them, and they're updated every year for them. You have our website here. We have a lot of stuff along with the division that regulates all the co-op, condos, HOAs, mobile homes, and timeshares. They're in charge of all of that, and I've got that information for you. I am going to get back to answering your questions as soon as I send you to the right places. You will receive a certificate only if you complete the survey at the end of this course. And if you don't complete the survey, that's what I get the spellings of the name for and the information for the certificates. So please be sure to complete the survey, put your name in it as you want it to show, and the email address you want your certificate to go to. Website that will get you copies of all this information, all the handouts that we've put together, is www.royalmanagement.com/board-certification-handouts/ and everything will be there. That page is hidden. If you don't have this address, you're never going to find it on the website. I have given you my email address so that if you have a question that I can answer, I'll be more than happy to try. I have given you our website. All of that being said, I'm going to go through the questions that are left and try and answer those for you. And I'm going to leave this slide up so that you've got the information until the very end. What is the term limit for board of directors? It is 8 years, but it didn't start until 2018. Nobody's reached the 8 years yet. The fact that you were on it beforehand, sorry, we originally thought they had done that. And then when they revised the law, because the lawyers all disagreed, the division disagreed, they made it very clear that it was going forward from an act. Governing documents stated that the association is a not-for-profit corporation, but calls itself an HOA, should Florida Statute 716 be followed. Both all of these not-for-profit corps are set up under 617. Because you're under 617, that does not mean, if your governing documents say that you are a homeowners association, okay, or a homeowners association, the newer ones will typically say under Florida Statute 720, you are governed by both 617 and 720. And usually the governing docs will say both, but there are some older ones from before Florida had 720 that just say you will be a homeowners association. And if they say that, then you are governed under 720 of the Florida law. If it says you will be governed under the condo provisions, then you'd be governed under the condo provision 718. All right, hopefully that answered that. Are you required to send certified letter to review the records? So that's a very good question. Are you required to send a certified letter to review the records? That's a dispute I have with most of the lawyers. So Florida law basically says that if you want the division to take up for you if records are not provided as required, you need to have sent a certified letter. Otherwise, you don't have a case to claim you asked for the records. There are some lawyers that tell associations you should never provide anything that's not requested by certified letter because you don't have to. That's really not what the law says and the intent of the law. The intent of the law is to make records easily available to owners. But if the association fails to provide those records without having sent a certified letter requesting them, you don't have any recourse. We receive requests all the time by email. People call us and ask for stuff, and people write us letters. They stick it in with their check and send it, and we try to comply. We also, all those records are on our website, and people can get to that. And because the idea of the law is to create transparency and make records available. But if your association refuses to provide records or does not make the records available, and you have not requested them by certified letter, you do not have a leg to stand on to go to the division and file a complaint. I can do to help you. Thanks again for attending. It's been my pleasure, and I hope to see you all again on another presentation in the future.